Hello everyone, I once again welcome us to our page of the law. My name is Joel, and today I want us to look at hierarchy of courts in Uganda, the court system in Uganda. So this is under introducing law. So let's be guided by this question. Wendy has come to you and is seeking to understand the principles courts apply in adjudicating both civil and criminal cases. She is also seeking information on the jurisdiction, composition, and hierarchy of courts of law in Uganda. Kindly help her better understand what she seeks to know. So Wendy wants to know three things, actually four things. One of them, first of all, Wendy wants to understand the principles courts apply while entertaining both civil and criminal cases in Uganda. Then secondly, Wendy also wants information about the jurisdiction of our courts, the composition of our courts, and the hierarchy of our courts in Uganda, right? So we are going to be guided by the following legislations. We're going to look at the Constitution of the Republic of Uganda 1995 as amended. We are going to look at the Judicature Act Cap 13 as amended. We're going to also look at the Magistrates Courts Act Cap 16 as amended. We shall also look at case law, right? So what is law? The Black's Law Dictionary 9th edition at page 962 defines law as the set of rules or principles dealing with a specific area of a legal system, right? We should also understand that we have three arms of government with three distinct functions, right? We have the legislature, which makes law under Article 71. The legislature or parliament makes law under Article 71. So the function of the legislature is to make laws. So after parliament has made this law, the judiciary interprets this law, right? The judiciary interprets the law. After interpreting this law, the executive comes in to enforce this law. Are we together? So let's look at the principles courts apply when adjudicating both civil and criminal cases. And Article 126, Clause 2 of the Constitution stipulates out the principles which must be followed by courts in Uganda while adjudicating cases. And these we're going to look at principle by principle. One, they're telling us that justice shall be done to all people regardless of their social and economic status. This means that while adjudicating cases, courts must not favor the rich who are in wrong over the poor whose rights have been infringed on or violated. So this means that everyone is equal before the law. That's one of the principles courts use. Everyone is equal before the law, regardless of your economic and social status. Whether you're poor or rich, you're equal before the law. Then secondly, the Constitution also provides that justice must not be delayed. We all understand that justice delayed is justice denied, right? Justice delayed is justice denied. Therefore, courts are urged to deliver justice in a timely manner. This could perhaps be the reason why the Ugandan government has tried extending justice to every district through establishing high court circuits and magistrate courts. You've seen in your districts or home areas, you have very many magistrate courts within. So they're trying to extend justice near to people, because justice delayed is justice denied. So that's the second principle. Let's look at the third principle. The third principle says that adequate compensation shall be awarded to victims of wrong. Adequate compensation. So, under civil law, if your right has been infringed on, you can apply for damages and you can be compensated. Are we together? Then in criminal law, if evidence is brought that indeed this person committed an offense, they should be punished adequately. Are we together? So this other principle is telling us that adequate compensation shall be awarded to victims of wrongs. In criminal law, I've told you, punishment must be adequate enough to compensate the injured party, right? As well, in civil cases, damages should be enough, right? Because civil law, we want damages. We do not want imprisonment, right? We want damages, punishment through damages. Are we together? So let's look at the very last. Is it? Yeah, the very last. No. Last but not least, courts are also urged to promote reconciliation between parties. It is apparent that proper court system is strict, time-consuming, and costly. Therefore, the Constitution directs that where court is faced with a dispute which can be settled outside court, then courts should give parties the opportunity for alternative dispute resolution. You very well know our courts in Uganda, right? We have a problem of case backlog. Therefore, the Constitution is telling us that one of the principles that courts should bear in mind while adjudicating cases is that you should give these parties an opportunity to resolve their dispute in an alternative way. For instance, we have mediation, negotiation, conciliation. Are we together? Without going to the proper recourse of the legal system we have in Uganda, right? Anyways, then lastly, they are telling us that substantive justice must be administered without undue regard to technicalities. Substantive justice must be administered without undue regard to technicalities. I'm sorry, I'm going to quote a certain case that most of you have not yet encountered, but you look at it when you get to second year doing land transactions. It's called Frederick Zawe versus Orient Bank, Uganda Limited, and 5 others, Supreme Court Civil Appeal number 4 of 2006. It was noted that Rule 81, Sub Rule 1 of the Rules of the Supreme Court required that a memorandum of appeal should bear arguments or narrative and grounds of objection of the decision, but the appellant's memorandum entailed the above prohibitions and infringed that rule. Initially, court would not entertain such a violation, but for the interest of justice, court decided to overlook the defects and determine the appeal. You very well know that when you're going to court, there are certain rules that you have to follow while drafting pleadings, right? So in case you make a mistake in drafting those pleadings, courts are at liberty to tell you that I mean to strike out your pleadings. But due to the interest of justice, such technicalities, so here we call them technicalities, such technicalities can be overlooked and justice be I mean for the interest of justice, yes, right? So let's look at the jurisdiction. So those are the 5 principles that courts consider while adjudicating both civil and criminal matters, right? Timely manner, equality, an opportunity for alternative dispute resolution, administration of justice without undue regard to technicalities. Then lastly, adequate compensation. Are we together? Then let's look at I'm sorry, I'm being a little fast, but let me try to slow down. Let's look at the jurisdiction of court. What is the term jurisdiction? The term jurisdiction, actually, in simple terms, jurisdiction means power of court. Simply that, power of court. But I'm not an authority. So let me give you this case. In the case of owners of motor vessel Lilian versus Caltex Oil Kenya Limited, 1989, Kenya Law Report. Jurisdiction was defined to mean the authority which court has to decide matters that are before it or take cognizance of matters presented in a formal way for its decision. So it is the authority for court or the power of court to determine matters before it. Are we together? Okay, that's the jurisdiction. So let's look at the jurisdiction of the courts we have in Uganda. So we're going to look at the jurisdiction together with the composition, together with the hierarchy. What comes first? Let's look at the Supreme Court of Uganda. So the Supreme Court of Uganda is headed by the Chief Justice, and is currently known as Justice Alphonse Owinyedolo, right? So the Supreme Court is composed of other justices not less than 6 in number, that is provided for under Article 130 of the Constitution. However, Section 3, paragraph B of the Judicature Act provides that the Supreme Court can also consist other 10 justices alongside the Chief Justice. Hence, the Supreme Court is composed of 11 justices per the law, right? That's what the law says. So the Supreme Court is also the final court of appeal in Uganda and shall have jurisdiction to hear appeals from the Court of Appeal. Are we together? So the Supreme Court is the final court of appeal in Uganda. So if at all if at all the Supreme Court has given you a decision, or it has made a judgment, you cannot appeal against that judgment because it is the final court on record, right? So we've been also told that the Supreme Court only hears appeals from the Court of Appeal. Are we together? Anyways, Section 7 of the Judicature Act also provides that the Supreme Court may have the powers of the court of original jurisdiction while entertaining cases, for example, presidential election petitions. So we should understand that for presidential election petitions, we do not start with the High Court or Court of Appeal. We go straight to the Supreme Court because it has original jurisdictions to entertain presidential election petition. Are we together? Anyways, for reference, you can look at the current case of Chagulanyi Robert Sentam versus Yoweri Kaguta Museveni, Supreme Court's election petition number 1 of 2021. Right? So that's the Supreme Court for us. What we should note is that it is the final court of appeal, right? So, secondly, it entertains appeals from the Court of Appeal, right? Okay, let's look at the Court of Appeal. So, this is the second highest court in the hierarchy of in Ugandan courts. It is headed by the Deputy Chief Justice, known as currently Honorable Richard Butera, and 14 other Court of Appeal justices, making them 15 in number. However, the Judicature Act was amended just of recent, so I think they're now 50 something. Yeah, right now there's 50 something because we have the new amendment of the Judicature Act, which increased on their number, right? So the Court of Appeal hears or entertains appeals from the High Court, right? So you do not go direct to the High Court. To the Court of Appeal, right? But you first have to go to the High Court. Then, if at all you want to appeal, you appeal to the Court of Appeal. That's why they're here. They're telling us that it only entertains appeals from the High Court. It should also be noted that the Court of Appeal at times also sits as the Constitutional Court, right? The Constitutional Court. So, article what? No. Okay. Article 137 of this Constitution provides that the Court of Appeal shall also sit as the Constitutional Court, consisting of 5 justices who shall entertain all questions regarding to the interpretation of the Constitution. So if you want the Constitution to be interpreted, it is only the Court of Appeal which shall sit as the Constitutional Court to have the Constitution interpreted. Are we together? And if at all it is sitting as the Constitutional Court, it should comprise of 5 judges or justices, right? Anyways, let's look at the High Court, the High Court of Uganda. This is headed by the principal judge currently, Honorable Justice Dr. This person, Flavian Zeija, and such a number of justices, or judges as prescribed by law. Article 138 of the Constitution, it provides for that. So the High Court has got 7 divisions as a way of effectively administering justice in a timely and organized manner. So the High Court has divisions. We have 7 divisions right now. They include, we have the criminal division, the civil division, the commercial division, the land division, the civil civil division, criminal division, commercial division, land division, family division, and corruption division. And they 7 already. Yeah, I think there are 7. So we have 7. So each division hears and determines a different categories of cases. So let's begin with the criminal division. Of course, criminal division, it only entertains criminal offenses or criminal cases, right? Criminal cases. So as you go further, I think you look at it when you get to next semester. I think when you're looking at criminal liability, you look at the 7 grave offenses which can only be had by the High Court. So for criminal law, for criminal offenses, for criminal cases or offenses, we shall file our suit or our suit to the criminal division. So what of the civil division? This hears and determines only a given number of civil cases such as torts, contracts, among others. So the civil branch or the civil division only determines a number of civil cases such as torts and breach of contracts, among others. So let's look at the commercial division. This division has jurisdiction to try commercial related disputes such as insolvency, bankruptcy. No, actually insolvency is the same as bankruptcy. Insolvency and laws relating to sale, among others. So anything to do with commercial law, we go to the commercial division. So land division, just like you hear, land determines land cases. The international crimes division, its mandate is to determine cases related to crimes committed outside Uganda's jurisdiction. So you could look at section 4 and 5 of the Penal Code Act. Yes, look at the family division. This division only entertains disputes arising from domestic relations like divorce, law relating to children, among others, right? Family court, domestic relations. So if you talk about domestic relations, we are talking about marriage and all that, yeah. Anyways, then lastly, and corruption. So of recent, we have they're called abebitiwa. Yes, we have abebitiwa. So for cases committed by those so-called abebitiwa shall go to the anti-corruption division, right? Corruption. Any corruption cases are called white collar cases. Yes, white collar cases. So all white collar cases are determined by the High Court and Corruption Division. So we are still looking at the High Court, right? So it should also be noted that by virtue of Article 138, Clause 2 of the Constitution, the judiciary has created a number of high court circuits or branches in every district in Uganda in a bid of ensuring that the high court is accessible to all people. Are we together? So we have branches of the high court. So for instance, in Mukono we have the high court. In Mukono we have the high court in Kampala. Actually, the high court in Kampala is the headquarters. We have the high court of Jinja, Iganga. We have high court. We have Masaka High Court. So it's just a branch, right? So it should also be noted that the high court has power to hear and determine a case whose subject matter. In civil cases, the High Court, regardless of the fact that the High Court has unlimited original jurisdiction, but it only has power to determine civil cases, whose subject matter is 51 million shillings and above. 51 million shillings and above. And for criminal cases, only the 7 grave offenses. We have the 7 grave offenses, namely murder, aggravated defilement, rape, terrorism, treason, aggravated robbery, kidnap with intent to murder. Those are the 7 grave offenses which carry the maximum penalty of death. So for these 7 offenses, it's only the High Court that it's where the High Court has original jurisdictions to entertain them. Are we together? So we shall see other cases where to report them. So let's go to magistrate courts. Hope you've understood me. So let's go to subordinate courts. So whenever you hear about subordinate courts, they mean magistrate courts. So magistrate courts are divided into 3. That is to say, we have the chief magistrate, we have magistrate grade 1 and magistrate grade 2, right? So let's start with the chief magistrate. The chief magistrate courts, these are headed by chief magistrates and try civil cases whose subject matter is 20 million shillings. Above 20 million shillings but below 50 million shillings. Are we together? So chief magistrate courts entertain civil cases whose subject matter is above 20 million shillings but below 50 million shillings, because we've said that above 51 million shillings we shall go to the High Court, right? If it's a civil case, right? For that, you look at section 207, subsection 1, paragraph A of the Magistrate Courts Act. And for criminal cases of criminal offenses, we look at its jurisdiction being trying offenses whose penalty is not death, right? It also has jurisdiction to entertain criminal offenses whose penalty is not death. You look at section 161, subsection 1, paragraph A of the Magistrate Courts Act. So we've said for civil cases, Chief Magistrate, for civil cases, if the dispute or the case's subject matter is 20 is above 21 million shillings but below 50 million shillings, it has jurisdiction to try that offense. To try that case. And for and for criminal offenses whose penalty is not death, the Chief Magistrate shall have jurisdiction to entertain that case. So let's go to Magistrate Grade 1. These courts have jurisdiction to try civil suits whose subject matter is below 20 million shillings. So you look at section 207, subsection 1, paragraph B of the Magistrate Courts Act. And for criminal cases, it has the jurisdiction to hear cases whose penalty is not death and not life imprisonment. You will look at section 161, subsection 1, paragraph B, Magistrate Courts Act. Anyways, let's look at Magistrate Grade 2. These courts have jurisdiction to try civil cases whose subject matter does not exceed 500 shillings. 500,000 shillings, right? So for that, reference is made to section 207, subsection 1, paragraph C of the Magistrate Court Act, and criminal offenses other than those provided for in the first schedule of the Magistrate Courts Act. So that's the jurisdiction, composition, and principles governing courts while adjudicating both criminal and civil matters. So that's how you should answer that question. First of all, in case you're given such a question, you should begin with Article 126, Clause 2, yes, and give us the principles. Then after you tell us each court and its jurisdiction, its power to entertain both a civil case and a criminal case, right? Anyways, thank you very much.